You already know about the importance of regulating AI, but what regulatory initiatives already exist? In this video, we will take a close look into a specific norm, the European AI Act. The AI Act intends to increase trust and respect for fundamental rights, values, and safety. This new regulation applies alongside and does not modify existing laws, such as the General Data Protection Regulation. But why is the AI Act so important? Well, it is the first legal instrument that applies to different actors directly. Also, following the idea of the Brussels effect, constructed by Bradford, the EU has been re-establishing its power by setting paradigmatic regulations that influence the whole world. The AI Act is one example of this scenario, being the first binding rule to regulate the life cycle of AI systems. Similar to what happened to the protection of personal data, it is very possible that the European AI Act will be the threshold of principles and rules regarding AI systems. Since stakeholders will most likely have to comply with the AI Act to be in the European market, the regulation will have a central role in the global artificial intelligence market. Concepts are crucial for understanding if a law applies or not to a certain situation. That is why we will go over the concept of artificial intelligence adopted by the AI Act. Intending to adopt a broad, technology-neutral and future-proof concept, the AI Act defines artificial intelligence as a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment and that, for explicit or implicit objectives, infers from the input it receives how to generate outputs, such as predictions, contents, recommendations, or decisions that can influence physical or virtual environments. This is indeed a very broad concept, which leads to a broad application. Examples that fall under this concept are chatbots, ChatGPT, smart objects, Alexa, recommendation systems used in health, leisure, the judiciary, between so many others. But when does the AI Act actually apply? It is applied whenever you are placing on the market, putting into service, or using AI, or also whenever you are placing on the market general-purpose AI. This confirms that the regulation will be very relevant and may affect a high number of AI systems. Of course, considering the complexity of the norm, it will follow a scalonated applicability, with most rules applying as of 2026. However, it is important to mention that the regulation does not apply to certain cases. For example, when individuals use AI systems only for non-professional purposes, or when systems are used only for scientific research and development. Additionally, the AI Act targets risky AI systems, following a risk-based approach with focus on preventing harms. But what does a risk-based approach mean? It means that risks should be assessed beforehand and that the bigger the possible risks, the more obligations apply. With this, the AI Act even prohibits very risky technologies. It is different to the rights-based approach, a scenario where rules apply directly to stakeholders and subjects can also enforce rights directly, regardless of the assessment of risks that a certain product or activity entails. Various jurisdictions have been applying the risk-based approach, which can illustrate the influence the EU has in the global regulation. But the risk-based approach is not the only solution for regulating AI. However, we will go over the levels of risks that the AI Act presents. The highest, the riskiest, is the technology that presents unacceptable risks, which lead to a complete prohibition of that AI system. One example of this is a technology that aims at predicting if a person may commit a crime in the future. After that, we have high risks, bringing obligations of prior conformity assessment and other specific requirements to protect health, safety, and fundamental rights. To exemplify the category of high risks, we can mention AI use for criminal investigations, systems to automatically select admissions in education, and various uses of biometrics. With lower obligations, we have the category of limited risks that require specific transparency obligations, as informing individuals that they are connecting with a bot in a chat, for example. Finally, when minimal or no risks are assessed, the AI technology can be used without any other restriction, besides the ones set by other laws, as the GDPR. The risk-based approach is reflected in the full AI lifecycle. For instance, the AI Act sets different obligations to different actors, such as the provider, the importer, and the deployer, considering the risks related to each activity. It is important to mention that sanctions for non-compliance are already foreseen. So, in case you are working with AI systems, it is fundamental to understand if and how the regulation applies to you and start with your compliance measures.